But what do you do about modification pieces? I guess I don't understand your argument insofar as I had taken the United States to always take the position, and I actually had a case about this when I was a district court judge, where the question was, were these flat metal pieces that were mailed internationally to the defendant machine guns? And we were all confused. The jury was confused because we had this notion of what a machine gun was, and the government argued that this metal piece was a machine gun and brought in experts that said under this statute, anything that can be used to convert a regularly operating semi-automatic weapon into one that rapid fires qualifies.
I'm sorry, Justice Jackson.
That's wrong?
Rapid fire is not the test under the statute. It's not whether it fires rapidly. It's whether it fires more than one shot automatically by a single function of the trigger.
I'm sorry.
Okay.
They said it could, but what we focused on was not whether that metal piece changed the way the trigger operated. Now, maybe you're saying that's wrong, but I guess what I'm focused on is that your argument seems to rest on the assumption that the function of the trigger, as Justice Alito says, is what the trigger does inside the gun.
That's correct.
Why is it irrational, wrong, et cetera, to think of the function of the trigger as what it does to cause the weapon to automatically fire more than one shot? If that's what we mean by function of the trigger, which is in the statute, automatically more than one shot, and what we're saying is if one operation causes the trigger to causes the function of the trigger to make the weapon automatically fire more than one shot, I guess I don't understand why your reading is preferable to that when the common understanding of a machine gun is that it is doing this sort of thing at the end of the day.
Well, it's because the trigger on a bump stock equipped rifle does not cause the rifle to automatically fire more than one shot. You still have to have manual action by the shooter in response to every single shot that gets fired. The shooter has to continue to thrust that forestock forward.
Okay, and if that's true, that's true.
It is true,
yes. Okay, that is a distinction. My other question then comes in. Why is that distinction matter from Congress's perspective in terms of it writing a statute that it was trying to prohibit that? If you're right that that's the relevant distinction, I guess I need a reason why there's something inherently so much worse about a situation in which you push it forward rather than pull it back, that we can reasonably say that that was a particular category that Congress wanted to prohibit. And that's what I'm missing in your argument. It doesn't make sense to me that we're going to identify guns on that purpose and say those are the ones that are prohibited when others that achieve the same result are not.
It's because the statute was written in 1934 and Congress wasn't thinking about bump stocks when they wrote this statute.